The Supreme Court has ruled to limit the power of lower court judges to block policies issued by the president. That ruling came out of cases involving birthright citizenship. The justices ruled that district court judges do not have the authority to make nationwide injunctions that block the president's executive orders.
Three federal judges, one in Washington State, one in Maryland, and one in Massachusetts, didn't just rule on the issues involving the parties and the states before them. They made their rulings apply nationwide across the board to everyone. So that was the issue in the case. Can one federal judge essentially dictate policy nationwide? And in its opinion today, 6-3 ruling by Justice Amy Coney Barrett, the Supreme Court said this is not how the system was set up to work.
The justices have not yet ruled whether President Trump's executive order ending birthright citizenship was constitutional. But President Trump thanked the court for their original decision, saying it will clear the way for him to move forward with his policies.
This decision, and thanks to this decision, we can now promptly file to proceed with numerous policies that have been wrongly enjoined on a nationwide basis. And some of the cases we're talking about would be ending birthright citizenship, which now comes to the fore.
In a statement, San Francisco City Attorney David Chu, who has filed multiple lawsuits against the Trump administration, said today's Supreme Court decision has profoundly disturbing implications for our rule of law. More now on the Supreme Court ruling involving President Trump's effort to overturn birthright citizenship. It was one of a series of decisions handed down by the High Court today on their final day of the term. Reporter Natalie Brand breaks it down for us.
In a 6-3 decision, the U.S. Supreme Court ruled Friday to limit the power of judges to issue nationwide injunctions to block a president's executive order. The opinion, written by Justice Amy Coney Barrett, split along the court's ideological lines. It says in part, these injunctions, known as universal injunctions, likely exceed the equitable authority that Congress has granted to federal courts.
She's also saying very clearly that when people walk into federal court now and they ask for relief of an executive order, they cannot get these universal injunctions anymore. Instead, courts are limited in the scope, the remedy that they can provide.
The ruling did not touch the issue of birthright citizenship, protected by the Constitution's 14th Amendment. In the dissent, Justice Sonia Sotomayor writes, no right is safe in the new legal regime the court creates.
Federal judges in Washington, Maryland, and Massachusetts blocked that policy nationwide, saying it violates the Constitution. Their injunctions escalated all the way up to the U.S. Supreme Court, calling into question the power of a single lower court judge to block a presidential policy.
The Trump administration's emergency appeal said the lower court's ruling should only apply to individual cases, not the whole country.
In the dissents, what you saw was an argument that, okay, yes, there is a proper process, but there are certain cases where it would be appropriate for a single court to issue a nationwide injunction.
The fight over nationwide injunctions goes back years, with presidents from both parties criticizing them, but the issue has been amplified by the Trump administration, facing more than 200 legal challenges so far.
The cases challenging the president's executive order trying to end birthright citizenship have been sent back to the lower court for review. The Supreme Court releasing rulings on a total of 6 cases today. So here is where those cases stand. The Supreme Court decided not to rule on a case challenging congressional maps. They upheld a Texas law requiring age verification for pornographic websites. The court kept in place decades-old programs to deliver internet access to rural areas. And they also rejected a challenge to part of the Affordable Care Act regarding preventative care. And in a 6-3 decision, the court ruled parents of elementary school students can have their kids excused from reading LGBTQ inclusive books.